Hi everyone, welcome tonight. Thank you for coming out. My name is Cristin Lowe and I am a divorce attorney, and tonight we are going to be going over all of the divorce forms that you need to get started in the divorce process, and we are going to be helping you. And the reason why we're doing this for you for free is because we love what we do. I really enjoy being a family law attorney. I enjoy helping people through a really difficult time in their lives, and when I go to the courthouse and I see people struggling and trying to get through the divorce process on their own, it's really hard, and I can't help everybody with their divorce, but I'm hoping that by giving seminars like this that I can help more people than I do right now. So I hope you're comfortable. The reason why we're doing it here instead of at the courthouse, first of all, budget cuts, there's no way they're open tonight. And second of all, we have a little bit more updated equipment and technology than they do, so you don't have to deal with the 60s projectors. All right, so we have our person set up. I have pulled an innocent victim out of this audience, and they're going to be helping me type the forms just to show you that anyone can do it, and it is accessible and it is doable. So we're just going to do this real time, and mistakes and all, we're going to keep going. So if you have any questions, and I know it's hard and this might be a little bit embarrassing to be asking your personal question to everyone here, so you can talk to me afterwards. If not, give me a call afterwards. If you need to email me, let's do that, and we'll make sure everybody has my contact information. And then with that being said, let's get started. Okay, so we're going to start with our first form tonight, and that is the divorce petition. And so let's go up to our link for commonly used forms. And we are going to, once it loads, we're going to go up to the tab that says divorce, because that's what we're doing tonight. And we are going to start with the FL100, which is the petition. Just so you know, all of these forms are numbered, and you can see the number in the far right hand corner. So FL stands for family law. And we're going to start with 100, which is the very first form in the form series. So with every single form that you are going to fill out, whether you're the petitioner or the respondent or whatever party you are, you're always going to start by filling out the caption. And the caption is basically the first half of this page, and you can see it all on the screen here. And every caption is going to be filled out identically from here on out. But since this is our first form, we're going to show you exactly what you need to do. So we're going to start at the very top, and the very top box is where your name is going to go. Because you are self-represented, it's going to be your name. If you had an attorney, your attorney's name would actually be up on there. And the way I instruct you to fill this out is exactly how you're going to fill it out every single time. So tonight we are going to pick the name Jamie Smith to be our petitioner. So just so you know, in California, it's a no-fault state. A no-fault state means it doesn't matter who files for divorce or the reasons for why you file for divorce. So the term petitioner or respondent, actually, they're just titles. So don't worry about if you're the respondent or the petitioner. So Jamie lives at a specific address, and it doesn't have to be the physical address that you live at. So Jamie's going to live at, and we're just going to pick an address here, but it has to be a good, valid mailing address that the court can reach you out. You don't want to put, for example, the house that you know you're going to move out of in 2 months. You might want to put your parents' address, you might want to put your friend's address, you might want to even put a P.O. box number. But the important thing to do with both the street address and then the city and the state and the zip code that you put in there, what matters is it has to be an address that the court can reach you at. So in this case, Jamie lives at, let's say, any town and somewhere in California, and then we have a zip code here. And then we have to also put a phone number, and again, the phone number is very important. It doesn't have to necessarily be a landline or a cell phone number or your work number. It just has to be a valid number that you and the opposing party can be reached at. I misspoke there, meaning the number that you can be reached at. So whether it's the court calling or the opposing party calling, they have to be able to reach you there. If you have a fax number, you can put that down. It's usually reserved for attorneys because we still use the antiquated fax lines, but I guarantee you no judge or court clerk is going to reach you at a fax line. With an email address, some courts, depending on the county, use email addresses now. So if you have a valid email address, it's a good idea to put it there, but it is 100% optional. And so Jamie, we're going to put Jamie's email address there. And again, this is all fictional. And underneath there, there's a caption that says attorney for. In this case, you're doing this on your own. So we have a term, and it's a fancy schmancy Latin term. It's called in propria persona. But we can abbreviate that by calling it in pro per. So it's 3 words, in, I-N, and then pro, P-R-O, and then another space, and then per, P-E-R. And that just lets the court know that you are self-represented, meaning you're doing this on your own without an attorney representing you. Okay, we're going to use the County of Contra Costa because that's where we are tonight, and this is where my main office is located, which is in Contra Costa County. And then the street address in Contra Costa County, we only have one family law building right now, and that's at 751 Pine Street. And the mailing address is actually a P.O. box, and it's P.O. Box 911. And then we are located in Martinez. I'll just go down to the city, put Martinez down there, and we're in California. And the zip code is 94553. The branch name is actually the Peter L. Spinetta Family Law Center. It's an optional thing. If you want to put that in there, that's great. But just so you know, if you're in Contra Costa County and you're going down to the courthouse, that's the building you're looking for, is the Peter L. Spinetta Family Law Center. And then we're going to go down to the next caption, which is petitioner and respondent.
How do we fill this one out? Or should we just leave it blank?
Like I said, you can leave it blank.
Okay.
It's totally optional whether or not you want to fill it in, so it's more of an FYI. When you're going down to the courthouse, if you live in Contra Costa County, you can go to the Peter L. Spinetta Family Law Center, but it's not required for this form. So let's go to marriage of. So petitioner, in this case, we are the petitioner, so it's Jamie Smith. And let's say that Jamie Smith is married to the respondent, who is Dale Smith. And just so you know, by filling out this form, by being the petitioner is always going to be the petitioner. It doesn't matter if you are responding to a motion or you're responding to something else. You are, for all intents and purposes, always and forever going to be the petitioner. If you are the respondent, you will always be the respondent. And that never changes. So let's scroll down a little bit. You'll notice that I'm actually leaving the case number blank, and that's because you're not assigned a case number until you file your papers with the court. Once you get a case number, you will always want to fill that out. But because you are the petitioner and you are initially filing out the petition, you don't have a case number yet. You haven't actually presented any papers to the courthouse yet. All right, so you're going to first check the box petition for dissolution of marriage. So dissolution of marriage is a fancy term for basically divorce. So let's go ahead and check that box. And now we are actually on the form itself. So we're going to start with number 1, residence, and it says for dissolution only. And because we're doing the divorce forms, this is applicable to us. We need something called jurisdiction. So jurisdiction means the court's ability to have authority over you. So in order for the court to be able to make rulings or decide on issues in your divorce, or in other words, have jurisdiction over your divorce, we need one of you to be a resident. And in California, we define residency as living in California or this state for a minimum of 6 months, and in the county in which you're filing for at least 3 months. And it doesn't have to be both of you. That's why we have both boxes. We only need one of you to be physically in the county for at least 3 months prior. So in this case, Jamie is the petitioner, and so we're going to check the box petitioner, and we're going to say Jamie has been living in California for at least 6 months and in Contra Costa County for at least 3 months. So whichever county you're filing in, either you or your spouse has to have lived in that county for at least 3 months. All right, so number 2, we've got some statistical facts. The first thing you're going to need to know is the date you were married. And it might have been a long time ago. You might have to go double check your marriage certificate, but please make sure to get this right. I've had more than one case where one or both people can't actually remember their date of marriage. So here, let's just keep it nice and easy, and let's say that Jamie and Dale married on January 1st, 2000. So you can write it numerically, you can write it out the long way, it doesn't matter. Now we have the second part, which is called the date of separation. So this is kind of a funny term, so I'm going to take a little bit of time and explain what that is. So date of separation is the date that you believe your marriage was over. It doesn't have to be the date that you physically separated, and in fact you can still be living together and file for divorce. It just has to be a day that you feel that the marriage was over. So we have basically your subjective opinion. Okay, I think we separated on this particular date. And for example, let's just pick January 1st, 2014, that Jamie says our marriage was over. And we have to back it up by objective behavior. So let's fill that out, date of separation, January 1st, 2014. And so that gives us a marriage, and then we have the length of exactly 14 years. And we don't have any months because they lasted exactly 14 years. Okay, so we're going to keep going down, and we're now on number 3. which is declaration regarding minor children. So we want to list children of the relationship, meaning of Jamie and Dale. We're not including stepchildren, we're not including children from prior relationships. All we are talking about are minor children, children under the age of 18 and still in high school, who are born to Jamie and Dale. So we're going to check, oops. We're going to check the box 3B, saying that there are minor children. And just for purposes of the example, let's have 2 children in the marriage. So let's have Susan Smith, and we will give Susan a birth date, and we'll make sure she's under the age of 18, so just pick any date. Oh dear, you're going to make me do math here. Attorneys are not very good at math, so that would make her 14, I believe. So we'll fill in the age, and if I got that wrong, I apologize, and the sex is female. And let's capitalize that F, please. So you can either write it all out, female, or you can just leave the F or the M. And let's have a little boy as well. Let's do a Robert Smith. And he's, let's pick another birth date, and if you can have a little bit of mercy on me and do an easy math one, please. Sometime in the 2000s. Okay, so that would make him 13, I think. And he's a boy. Okay. All right, so there are some other details down here, and I'm just going to skip those for now because we're just applying this to most people. There are some people that this goes an exception to, and it's a little bit more complicated. So if you have questions, let's talk afterwards, or you can give me a call. And we're going to actually skip down to number 4 now. And we're going to be talking about separate property. So separate property, and this is going to bring us back to the date of separation. The definition of separate property is anything that you got before you were married and since you were separated. So kind of on either end of the sandwich. We ignore the marriage, so anything you got before marriage and anything you got after the marriage is over, meaning the date of separation. We also have some things that are considered separate property items. For example, and the most common one is an inheritance. If you have an inheritance, that is presumed to be your separate property. There are a lot of other questions and a lot of other sub-issues within that, but in general, if you got an inheritance, that's considered your separate property. So let's, for example, say that Jamie has an inheritance. So how would we fill that out? We're going to actually check the box that says below, and it's on the left-hand side. Oops, technical difficulties here. So under the word item, we're going to say petitioner, that's Jamie, so petitioner's inheritance. And we don't have to be more specific than that. You can be very, very specific if you want, but you don't have to. So let's finish that up. It says petitioner, oops, let's spell that right. P. And let's do apostrophe S, space, inheritance. Okay. And then the second question that they ask is confirm to. Well, who are we going to confirm it to? Well, Jamie got an inheritance, so Jamie's going to say, I want that inheritance confirmed to me. So confirm to, we would either put, in this case, petitioner, and it's a T. And if, for example, the respondent had separate property, you would put respondent. But in this example, Jamie's saying, I have an inheritance and we're going to confirm it to me. And let's just, for example's sake, say that Jamie bought a house before marriage. So we're going to go back to item, and we're going to put down real property. That's the fancy word for house. You could put house if you wanted to, but the more correct term is real property. And then we want to be a little bit more specific. So we want to say located at, and let's just pick an address for example's sake. So real property located at, and then just put the address down. And then you would want to put a city and a state. Okay, and again, he or she would be saying confirm to the petitioner. Okay, so in general, separate property, anything acquired before marriage and after separation, and anything that you've got by inheritance or by a gift. Okay. So that kind of wraps up page 1. We're going to go on to page 2 now. And we're going to start off by filling out the very top caption. And if you use our forms, you'll see that it's automatically auto-populated with marriage of, and then we have the parties' names. And case number, again, that's going to be blank because we haven't filed anything with the court yet. So question number 5 would be declaration regarding community and quasi-community assets and debts. If you have, and you think you have quasi-community property, you definitely want to talk to an attorney. So I'm going to skip over that tonight because it's a little bit complicated and we just don't have time to get into that. And quite frankly, it doesn't apply to a lot of people. Community property, however, is anything that you've acquired during marriage. So from the date of marriage to the date of separation, if you obtained it during then, doesn't matter if it's your name, your spouse's name, your kids' names, we presume that it's community property. And by that, we mean it should be equally divided 50-50. It doesn't matter if you bought it, it doesn't matter if you incurred it. So everything you own and everything you owe from the date of marriage to date of separation, we're going to assume is equally liable or equally divisible. All right, so in this case, we are going to say that Jamie and Dale actually do have community property assets. So we're going to check 5B, and we're going to list them below.
So, click.
Yes, check that box. Okay, and here is where we would actually list everything that Jamie and Dale acquired. So, for example, if they purchased a house during marriage, we would list that down. I am a big fan of putting more details in. So I would list the real property located at, and I'd put the address down, and I'd put the city and the state, just like we did on page 1. And then I would also be saying, and its encumbrance. So encumbrance is another word for mortgage. So not just the house itself, but the liability, the debt. So we'd put an address down. Okay, so let's go back and capitalize the S. The court's not going to reject your pleadings if you don't have proper grammar and you don't have things capitalized and good punctuation, but it is an institution, so I do believe in giving respect, so I want you to be as proper as you can with the forms. And on top of that, it just makes you look like a professional. And its encumbrance is what I would put out there. Okay, so no apostrophe there. And we spell encumbrance E-N-C-U-M-B-R-A-N-C-E. And let's do a semicolon after there. And so most people, when they marry, they also obtain miscellaneous household items. So let's add that as well. And let's do another semicolon, and let's say these two, and most people do have vehicles. And let's just make them the average couple. They also have bank accounts. And this is where I'm saying you need some detail, but I don't necessarily need you to list. I have Chase account 1, 2, 3, 4, and I've got oh, I don't know, Bank of America 6667 or anything like that. So let's do another semicolon, and let's say Jamie and Dale have life insurance policies. And when we say life insurance policies, we're mostly talking about what are called life insurance policies with cash surrender value, meaning I could sell them. The ones that you get from your work, it's typically not considered property because you can't divide it, you can't sell it, it's not worth anything unless one of you dies. Let's do another semicolon and add retirement accounts. And a lot of people seem to think that unless I've been married for 10 years, I can't divide the retirement account. And that's actually not true. It doesn't matter how long or how short your marriage is. If you have a retirement account, it is absolutely considered community property. So let's put another semicolon in there. And let's go on and say they have credit card debts like most other people. So again, when we list all assets and debts, we do list all assets and debts. And we can put a period there. Let's end it. All right, so we're going to go down to number 6, and we are going to fill out A, which is dissolution of the marriage, And we are going to check the first box. So we're going to check A1, which is irreconcilable differences, meaning we don't care. It just means that we can't get along anymore and we want to dissolve the marriage. As much as many people want to put incurable insanity, it's actually a very, very difficult reason to get divorced. And so for most people, irreconcilable differences is it. And if any of you kind of watch the Hollywood gossip, you'll see they almost always file and cite irreconcilable differences. And I like to give the example, it doesn't matter if there's infidelity, it doesn't matter if there's drug abuse, it doesn't matter if you like your spouse's color of their hair and that's the reason why you're getting a divorce. Those are all considered irreconcilable differences. All right, so let's scroll down, because the rest of it's not applicable to us. They're for actually different types of cases, an annulment and a legal separation. So we're going to go down to number 7. So petitioner requests the following. So we're going to first start off with legal custody. So what is legal custody? Legal custody is who has the right to make decisions about the kids' lives, whether it's school, whether it's childcare, extracurricular activities, medical decisions, kind of those big ticket items. Who gets to make that decision? So there's 2 types. There's joint custody and there's sole custody. A lot of people come in and talk to me and they say, I want 75% custody. And that's not really possible here in California. So again, it's either joint or sole. And by your options here, you can see that exactly. So petitioner or respondent, you could check one of those boxes and that would be meaning petitioner wants sole custody or respondent wants sole custody. Or there's the box for joint. So either joint or sole. In this case, let's have Jamie asking for joint custody of the kids. And again, that's legal custody. Physical custody is 7B. So what is physical custody? Well, it's who do the children have to be with at any given point in time, subject to the other parent's right of visitation. So basically, the right to physically have your children with you. And in most cases, and we're going to make Jamie and Dale like most people, we're also going to say joint physical custody. It doesn't have to mean a 50-50 timeshare. It doesn't have to mean equal. What it means is both parents are heavily involved in their children's lives and both have substantial periods of time with the kids. Okay, so C is visitation. So that's your nuts and bolts. That's your day-to-day. Where are the kids with Monday through Friday? Or who are the kids with Monday through Friday? What do we do for vacations? What do we do for holidays? How is that all going to work out? That's really, really important. So I want you to think about that as far as what a parenting plan is going to look like. And again, you can go into a lot more detail here, and you can go into a lot more detail if you go to court. But for now, we're going to keep it very general, and we're going to say that both parents get visitation. So we're going to check both boxes for petitioner and respondent under child visitation. We're going to skip D because that's a little bit of a complicated issue, and we don't have time for it tonight, and it doesn't touch most people. So we're going to go on to 7E, attorney fees and costs payable by. I consider the petition kind of a wish list. It's a request. What is it that you want? By checking these boxes, it doesn't mean that you're going to get it, but it lets the judge know this is what you're asking for. And in general, if you are considering asking for something, it's better to kind of put it on the table now. You can always change your mind and back off. What you can't do is change your mind once it's filed. You can't take a lesser position, or sorry, a greater position. So you can't say, I'm not asking for attorney fees here, and then turn around and later on say, well, I want attorney fees. The judge is going to look at the papers and say, well, you didn't ask for attorney fees, so I can't give you attorney fees. So it's better to err on the side of caution. If you think you might be wanting attorney fees, then you would check the box attorney fees. So let's just say that petitioner or Jamie wants attorney fees. So let's check the box. If what you want to say is that both of you should be paying for your own attorney fees, you can either check both boxes or you can leave them both blank. Kind of says the same message. Spousal support. Again, that's one of those things that if you think you might want spousal support, you should check the box and ask for it. It's better to ask and then back off and change your mind than to not ask, because that creates a lot more paperwork and a lot more kind of time and effort. So if you want it, go ahead and check it. If you know for sure under no circumstance will you ever want spousal support from your partner or your spouse, then you would not check the box. All right, so we're going to go down to G, terminate the court's jurisdiction, and we learned the word jurisdiction earlier on today, so the ability. So you don't want the court to award spousal support to respondent. So in this case, if Jamie were to check the box, Jamie would say, I don't want to have to pay Dale spousal support under any circumstances. So let's just have Jamie check that box. H, that's a box that you always want to check, and that means property rights be determined. What does that mean? That means the judge has the authority to make orders regarding your property division. And in this case, where we gave the example, we have a lot of property. We have houses, we have retirement accounts, we have bank accounts. The judge needs to be able to have the authority to make decisions regarding that. And even if the two of you have a full agreement, the judge still has to have the authority to be able to make orders. All right, petitioner's former name be restored to. So all of that lecturing that I did about how you need to ask and just put it all out there, this is one exception, the only exception here. You can change your mind at any point in time if you want to restore a maiden name, or if you want to hyphenate, or if you want to switch the order of your last names. You can even do it after the divorce is finalized. So if you want a name restored or you don't want a name restored, you either fill it out or you don't fill it out. If you have no idea, I'd rather you leave it blank right now and then come back to it at a later time. All right, and we're going to keep going down. We're not going to make anything unusual or do any unusual circumstances, so we're going to keep scrolling down. And we are just about at the end of this form. Okay. And I just want to draw your attention to number 9, which is I have read the restraining orders on the back of the summons. We're going to get to that form later on tonight, but understand that when you sign this document, you're saying that you read the summons. The summons doesn't have a lot to fill out, so we're not going to spend a whole lot of time on the how, but we are going to talk about the what and the why and what does it mean. All right, so the last thing you need to do is you need to type your name. And you need to date it. You can handwrite the date or you can type in the date. It doesn't really matter what. But you're going to do it on the upper line. You're not going to do it on attorney for, because again, you're self-represented. So we just need your signature once. So in this case, we're going to put Jamie's name here. Okay. And then you are done with this form. So you are going to print it out and then you're going to date it. Just so you know, when you print it out, it's always in that upper left-hand corner. People miss it all the time, but you do need a date. And then you're just going to sign it. Okay. So we are going to save this form and it's going to go up and be available for handout. We're going to pass it out tonight so you all have an example of what to do. And we're going to take a quick break and then we're going to go on to the next form. Hi, I'm Cristin Lowe. Thank you very much for watching the video. I hope you found it helpful and I hope that I was able to help you through this really difficult time in your life. I'd like to invite you to hit like or comment or subscribe to our video series. If you have any specific questions regarding the form or regarding the divorce process itself, please email me directly at Cristin@CristinLoweLaw.com. Thanks again.